Hello, everyone. This is Steve Yoder, and I welcome you to week 12 in Legal Studies 246, the legal environment of business, here in the fall of 2016 at the UAB Collat School of Business. This week we are looking at employment discrimination law. We are spending all week on this chapter because it is an extremely important part of the law, particularly for those of you who will have some responsibility, directly or indirectly, for the human resources function. Note here that there is a chapter from the textbook, chapter 17. There are two sets of narrated slides, and there are several short additional videos or readings for you to do, and there is one quiz due on Sunday night, November 27 at 11:59 p.m. The primary law for looking at whether or not an employment action such as hiring, promoting, or firing might constitute illegal discrimination is Title VII of the Civil Rights Act of 1964, which, as you can see, protects people in the classes that are listed there: race, sex, color, religion, and national origin. Not everything is protected. Not every trait or characteristic that you might have is protected. For example, Walmart was free to discriminate against somebody who had used marijuana, even though that person was using marijuana for medicinal reasons. Being sick or using marijuana when you are sick does not put you in a protected class to protect you against discrimination in the workplace. We will be looking at the various protected classes under the Civil Rights Act of 1964. Note that color and race are two separate concepts. Religion is a protected class that means that employers may not discriminate on the basis of religion and must make reasonable accommodations as well. Title VII of the Civil Rights Act also prohibits discrimination based on gender, which has been construed to include sexual harassment. We will be spending a fair amount of time on this subject of sexual harassment because it is, I'm sorry to say, a problem in the workplace. You do not want to ruin your professional career by harassing somebody else or being accused of harassing somebody else. There are several things that people believe can't possibly be harassment, like calling somebody dearie, but in fact, that can be considered sexual harassment, so don't do it. There is a separate law that prohibits discrimination on the basis of age. That age is fairly young. If you are 40 or over, you are protected by the Age Discrimination in Employment Act. Here is an extra credit opportunity based on that law for 2 points. On the last exam, send me a Canvas mail message by Sunday night, November 27 at 11:59 p.m. Look at this article from March 2016 in the New York Times about two professors who sued a university alleging age discrimination, and all I want you to do is send me the name of that university by that time in a Canvas mail message. Yet another law protects us against discrimination on the basis of a disability. There are a lot of words in that law that require definition, including what is a disability. We will be looking at that. Another term that is embedded in that law is reasonable accommodation. Employers are required to provide reasonable accommodations for those who are, quote, disabled, such as a wheelchair ramp. Another concept we will be covering is affirmative action. Affirmative action represents programs that are designed to increase diversity in the workplace. That has been the subject of much litigation going back nearly 50 years when somebody challenged a quota system at the University of California Medical School that gave preference to white applicants, or gave preference to African American applicants over white applicants. The white applicants successfully sued by arguing that that violated the Equal Protection Clause of the Constitution. As recently as June of 2016, just a few months ago, the United States Supreme Court said that the University of Texas was constitutionally able to consider race and ethnicity in its admissions decisions, that that was not a violation of the Equal Protection Clause. Its argument at the University of Texas was that its goal was not to correct past discrimination, but rather to enhance diversity, and the Supreme Court said that is a permissible goal. Finally, take a look at the calendar. You can see that there is a VoiceThread assignment due on Sunday night, November 20. There is a quiz on Module 11 Agency Law and a quiz on Module 11 Employment Law, also due on Sunday night, November 20 at 11:59 p.m. And I wish you a very, very happy and safe Thanksgiving.